Do you remember when a lot of people said I was an idiot for opposing the charges against the Crumbley parents? Let me give you about a case. Should we charge this sheriff, a revered and retired third-grade teacher that everybody loved? Can you guess what he's been charged with? And then our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do. Leave me a comment below. Hit that little bell for notifications because, well, you know, YouTube drops a lot of people from notifications. And remember, you can catch us anytime on any of your favorite podcasting apps as well. Let's go ahead and open the record and begin the docket for February 2nd, 2024. The special judge, Fran C. Gull, that's right, that's her name, Fran C. Gull, set a hearing for 9 a.m. on February 12th in Fort Wayne, Indiana, to focus on two motions filed by the prosecution as it relates to the Richard Allen case. You know, the guy charged with 2 counts of murder for the February 2017 deaths of Abby Williams and Libby German near the Monon High Bridge, also known as the Delphi murders. So the new old attorneys, Bradley Rossi and Andrew Baldwin, will represent Mr. Allen after their reinstatement by the Indiana Supreme Court. It's going to be the first time a face-to-face appearance with Special Judge Fran C. Gull and the new old attorneys on the case. She clearly doesn't like them. They don't like her. Ooh, it's going to be good. Now, according to the court filings, the judge is expected to hear the issue regarding the motion filed by the prosecutors to amend the charges against Richard Allen and a January 29th motion filed by the district attorney seeking contempt charges against Mr. Rossi and Baldwin. Now, the same day that the Indiana Supreme Court, January 18th, reinstated Allen's attorneys and decided to keep Judge Francis C. Gull on the case, the prosecutor filed court documents seeking additional charges against Mr. Allen. Allen currently faces 2 charges. However, the amendments seek to add 2 additional counts of murder and 2 counts of kidnapping. Now, in the motion filed by the prosecutors, they argue that the investigative findings supported the idea that Allen kidnapped the girls prior to the murder. All right, ladies and gentlemen, a kidnapping isn't what a lot of people think, where you have to take somebody, tie them up, and move them to some secluded place. A kidnapping is moving somebody against their will, however slight. Okay, we could be talking inches. That's all it takes to be a kidnapping. Now, remember, these prosecutors think that the defense attorneys are a bunch of morons for the release of these documents by a trusted member or former member of their staff. But yet the prosecutors have investigated this case for 7 years. The guy that they thought that did it, they didn't have his report indexed, so they missed it for 7 years. They made the initial filing, the charging decision in this case, and nobody bothered to think, hey, the girls were moved down the hill, right? Remember the recording that everybody talked about? Go down the hill. And the prosecutors never thought until now, until when the new attorneys were asking for a trial to commence immediately, nobody thought of adding that charge of kidnapping until now. And the defense attorneys are the incompetent ones? Just saying. Okay, this is also not an unusual trick. I don't want to say trick. Trick makes it sound like you're doing something nefarious. It is a typical tactic when the prosecutor thinks or sees that you're actually going to trial to suddenly add more charges so that the defense can then say, well, I need more time to investigate, do what I need to do, when in reality it's really the prosecutor that wants the continuance. So we'll see. Like I said, this new motion seeks to charge Allen with 2 different types of murder, one for the killing in the commission of a felony and the other for the act of killing the girls. So, you know, once again, did he kill them because they kidnapped them, or was he actually a killer? Oh, maybe they're starting to think maybe there was more than one person. Interesting. Anyway, the distinction is, basically nuanced in the charging documents. It's also called felony murder, and it doesn't necessarily require the prosecutors to prove that actually it was Allen, Richard Allen, who actually committed the killings. So they're just going to say, well, you must have kidnapped them. So even if somebody else did it, you're just as guilty under the statute. So interesting that the prosecutors are going that way. Maybe somebody's going to say, well, the prosecutors are really smart, because if he's going to say all these other people did it and he was maybe there or part of it, but he didn't do it, he didn't kill anybody, then doesn't matter. We'll get a felony murder charge, which is where you kill another human being while committing or attempting to commit another crime, in this particular case, kidnapping. So we'll see. And the prosecutors are also seeking a kidnapping charge while adding the 2 additional murder counts for knowingly or intentionally killing another human being. Now, the state is asking for leave, which is just simply permission to file these amended charges, because the charges more accurately align with the charging information with the causes discovered in the probable cause statement, according to the district attorney. They quote, "Revelations regarding the evidence leak derailed this case in October when the court learned of the associate of defense attorney Baldwin had taken crime photos and distributed them to another person, and they disseminated them on social media." That was the leak that led the judge to call for the withdrawal of Baldwin and Rossi from the case. And then on October 19th, Special Judge Frances C. Gull announced in court that the 2 attorneys had withdrawn. She later appointed a new pair of attorneys. Baldwin and Rossi later contended they stepped down under pressure and fought for their reinstatement all the way to the Indiana Supreme Court. The case made its way all the way to the Supreme Court, which ultimately decided to reinstate the 2 attorneys. So now the new old attorneys are on the case, and the new attorneys are now the old attorneys. So there you go. Anyway, the prosecutors believe that the evidence leak is a key component in their filing, in which the district attorney sought to have Baldwin and Rossi held in contempt. The DA's outlined 25 points supporting his motion, with the October evidence leak and a second earlier inadvertent disclosure of discovery materials among them. In his filing, the prosecutor also wrote that the 2 attorneys rejected the idea of a gag order in this case back in November of 2022 and said they didn't plan to discuss the case in public. Then on December 1st, they issued a press release commenting on the investigation and stating their belief that Mr. Allen was in fact innocent. The prosecutors allege that had the gag order which was taken under advisement by the judge, been in place, the press release would have violated that order. Yeah, but it wasn't in place, so it doesn't violate it. Day after the press release went public, the court granted the motion for the gag order. Again, the hearing for both issues is set for February 12th. If we can bring it to you live, we will. Now, once again, Mr. Prosecutor, not telling you how to try your case, just saying, but quit worrying about what the defense attorneys are doing and focus on winning your case. Because I'm telling you, based upon their motion that they filed from the Franks hearing, that the court completely just dismissed and poo-pooed it and acted like the defense attorneys are a bunch of idiots, they may have raised some serious doubt if that is the cross-examination that is going to be submitted at trial. And if the witnesses are subject to their line of cross-examination, Mr. Prosecutor, you've got trouble. So why don't you focus your time on preparing your case to get it to trial as quickly as possible. You know, we're currently scheduled for October, but if, the motion to move that up, you should really focus on them. It seems like the prosecutor is a little upset that, one, the original attorneys are back on the case, so he's trying to get them thrown off by trying to say there's some sort of conflict of interest. The judge should completely table that motion until the case is done. And, it seems like, frankly, from what I've seen, I'll be honest with you, the prosecutor's getting out-lawyered by the defense attorneys. We'll see how this is going to go. All right, a prosecutor on the Chad Daybell case is stepping down. Ah, yes, Rachel Smith. Remember, she was the special Madison County and Fremont County prosecuting attorney from Missouri because she had all this death penalty experience. And she was brought in for the Lori Vallow and Chad Daybell murder case. She's going to be leaving the case at the end of February. Now, like I said, she was brought in, remember, a veteran homicide prosecutor who had assisted prosecutors since March of 2021. Now, Chad Daybell's trial is beginning on April 1st. They're in the Ada County Courthouse. Now, I'll be honest with you. I really don't know what Rachel Smith has done in this particular case. I don't know if she was working behind the scenes, but frankly, I don't have any recollection of her taking a single witness in the Lori Vallow trial whatsoever. I don't know. Maybe the people of Fremont and Madison County down there should be asking their prosecutors why they had to pay this attorney to do what apparently they were able to do just fine. Don't worry, it's just about the money. And it would have saved a lot of less trouble as it related to the litigation issues. And remember, the defense attorneys were always trying to get her off. Now, she was admitted pro hoc vice, which just simply means she's not licensed in Idaho, but that she was granted permission by the court to participate in the proceedings as long as one of the other attorneys was there. I don't think she did anything. I don't think she ever argued a single motion in court. Kind of a waste of money, in my humble opinion. All right. The threat of imminent incarceration tends to break the bonds of loyalty. All right. I've said this many, many times on this show, and it is so true. I've seen family members roll against fellow family members. And guess who did it yesterday? That's right. Mrs. Crumbley rolled upon her husband. So the Michigan mom, who's on trial for her 15-year-old son's school shooting massacre, threw her husband under the bus and blamed her husband and also cheating for his failing to lock up the guns. So Jennifer Crumbley, she's looking at 60 years in prison for the involuntary manslaughter after her son Ethan killed 4 kids at the Oxford High School back in November of 2021. Well, she testified that it was her husband, James, responsible to store their son's gun. When asked who was responsible for storing the gun, she said, "My husband was." She told jurors that the gun safety and maintenance was more his, referring to James, his thing, so I let him handle that. I didn't feel comfortable even putting the lock on that thing. Now, like I said, she's on charge for facing claims of neglect to her son's pleas for mental health support. And she told the court that her husband and the son bought the 9mm gun used in the rampage on Black Friday while she was out shopping, which means I never would have bought it had I known that they were going to do it. And also, like I said, the trial also exposed that Jennifer's extramarital affair with a local fire captain undermined her claims that they were a close family unit. Hey, listen, clearly dysfunction going on in the house, okay? Clearly. If she, Mrs. Crumbley, is with the fire chief, guess what? She's not paying attention to the husband. Husband's doing his own thing, okay? And she's probably focusing on new boyfriend, probably not necessarily on the kid. Is that neglect? I don't know. We'll see. I think it's silly that they're prosecuting the mom. I get it. She'll probably be convicted because it's so terrible, and they got to do something, and they must stop this. But let me give you an example here. Let me show you. Should we charge this police chief? I mean, after all, it was his home. So a police chief in a city here in Colorado. It's called Ouray, Colorado. It's kind of between Telluride and Montrose, Colorado, over on the western slope. Absolutely amazing. It's like going back in time, but some of the most spectacular mountains that you've ever seen. Absolutely beautiful. A friend of mine got married there, and it is just a beautiful, beautiful place. Small town, small city, mountain town where everybody knows everybody, and their tourism is their base of income as the year goes on. So anyway, the town of Ouray has been, the police chief for the town of Ouray has been put on leave after his teenage stepson was charged for allegedly taking part in a sexual assault of a 17-year-old girl at the police chief's home. And he was apparently asleep. So Chief Jeff Wood was put on paid administrative leave on Monday, pending the outcome of the proceedings against his stepson, Nate Diefendorfer. alongside the co-defendants Gabriel Trujillo and Ashton Whittington. Now, the city claims in a news release that the chief himself is not under any criminal or personal investigation, nor is anyone at the Ouray Police Department. But the city put a sergeant in as the interim replacement. Now, the three boys were arrested last month on warrants for suspected felony sexual assault, stemming from the allegations that they violently and repeatedly sexually assaulted a 17-year-old girl in the police chief's home back in May, while the police chief and other members of the family were apparently asleep. I don't know. Was that negligent to let teenage boys and a girl in your house? I don't know. Could have been. Why weren't you up supervising them? Do you see why the Crumbley thing, if it goes too far, really goes too far? Anyway, so this little story goes on another little twist because the local newspaper did a story about it. And guess what? Every copy was stolen from the racks throughout the city and county there of Ouray, according to the newspaper publisher. What we know is the 17-year-old accuser, the female, told investigators that she screamed and fought as she was sexually assaulted at least 3 times in a bedroom and bathroom back on May 14th of 2023. At the time of the alleged assault, Whittington had just turned 18, and they were celebrating the birthday, while Trujillo was 19, and Diffendefer was just a few days away from turning 18. So what that means is they can all be charged as an adult. What that means under Colorado law is they could be charged with sexual assault by force, which carries a mandatory minimum of 10 years to life in prison. Indeterminate life sentence. Bad stuff. Obviously, we'll give them the presumption of innocence, but just the allegations. Now, the young lady described joining the 3 males at Diffendefer's home and drinking some seltzer and gin before passing out in a bed. She said she passed out on the bed and awoke to find her clothes removed and Diffendefer on top of her having sex with her. She said she tried to fight back, but was restrained. She said that one of the male suspects was laughing while this was taking place, but another was sitting in a chair looking horrified, but did nothing to help her. Subsequently, the young lady said she was taken across the hallway to a bathroom where she was assaulted yet again by 2 different people. So an investigator with the Ouray County Sheriff's Office took an initial report at the hospital, but the case was later referred to the Colorado Bureau of Investigations. Good. Too bad we don't have investigator Missy Woods over there doing the DNA. Anyway, they did that to avoid the conflict of interest, and it's not uncommon in the smaller rural communities where the Colorado Bureau of Investigation takes over because they apparently have greater resources. So CBI says that the DNA evidence from the vaginal swab matched Trujillo and Diffendefer, and they matched genetic material recovered from a bite mark on the young lady as well. Now, Mr. Trujillo spoke with the investigators and said he and Diffendefer had a prior consensual 3-way sexual relationship with the young woman, according to the arrest affidavit. And he claimed that he was just a witness to the events of May 14, saying Diffendefer and the accuser went to the bathroom and came out some 10 minutes later, fully clothed, and everything seemed fine. He further called the young girl a pathological liar and someone who seeks attention, according to the affidavit. Now, Trujillo, Diffendefer, and Whittington are free on bail and have court dates coming in the future. As you can see, ladies and gentlemen, do we really want to hold adults responsible for things that their kids do? I mean, is it negligent to have alcohol in your home where underage people could get it and drink it? Is it negligent to have people over to your house when you're going to be sleeping and not knowing what could take place, where an assault of some type could take place? Charge the parents. I get it. It makes everybody feel good. But be careful, ladies and gentlemen. If everything is a crime or could be, what kind of world are we going to live in? And next on the docket. Yes. He was a revered and loved longtime 3rd grade teacher. Can you guess what he's charged with? That's right. Please meet Taman Bergengazi. This guy's 76 years old, and he had a court appearance the other day, and he pled not guilty to abusing 2 former students in Suffolk County. Now, Benghazi was arrested on December 21st and charged with 1 count of sexual conduct against a child in the first degree and 1 count of sodomy in the first degree. But guess what? At least 56 other victims have come forward and accused the former teacher at the Bay Shore Elementary School of abusing them when they were children. Of course, most are suing the school district because the law in New York allows people, when the statute of limitations had run, to go back and sue everybody that they think is responsible for sexual assaults. Don't even get me started. That's why we have statute of limitations. You have to come forward. In the criminal side, it's kind of a due process argument. You allow this to take place forever, but yet I can't go and get witnesses, the documents. It's a shakedown, okay? And don't get me wrong, if they've been abused, they should have done it, but they should have told somebody as well. Anyway, Benghazi worked as a 3rd grade teacher at the Mary G. Clarkson Elementary School and the Gardner Manor Elementary School between 1970 and 2000. He continued to work for the Bay Shore School District until 2003, and he was described as revered by students and colleagues in the district, with some parents even requesting their children to be placed in his class. Well, the prosecutors allege that the district officials knew about the abuse and turned a blind eye. I think we should charge the school officials too as well. If they knew, it's what they didn't know about. That's the issue. Well, Benghazi directed school plays as his time as a teacher. He coached sports after school and outside of work hours. Guess what he would do with his time, because he was so revered and loved and just loved the children, loved them. Yeah, he would take them to the beaches and go to the gym and the pool. Probably was in the locker room with them changing, because that's like, I'm telling you, ladies and gentlemen, I get it. I get it. You have kids, you love your kids. Did I ever let somebody take my kids without me being there? No. And maybe it's just because of the work that I've done over the years that made me so cynical, paranoid almost. And it's stories like this that make you wonder. And yes, I know there are lots of good school teachers. Heck, I represented somebody in a very similar situation just like this, and everybody loved him. And then they would think about every little time they put their hand on their back and patted them on their butt. Was it an innocent pat on their back, or was it something of a sexual nature? Well, I guess we just had to take a look at the old computer now, didn't we? Have you started to notice a theme here? Have you starting to notice a theme that takes place, ladies and gentlemen, when I say the threat of imminent incarceration tends to break the bonds of loyalty? That be careful of the people that are out there near your kids. Why are they in these jobs near your kids? Because that's where the kids are. Ladies and gentlemen, think about it. Use your common sense, okay? Check out those parents. Go to crimetalksearch.com. Go check out anyone that's going to be near your kids. Go to crimetalksearch.com. Do that background subscription search on everyone coming into your life. Do you think there's a reason why we recommend it? Do you think there's a reason why we promote it? Because I'm telling you, ladies and gentlemen, you are usually, when you do this, going to find something that you didn't know about the people near to you. All right, finally, our dumb criminal of the day. Now, have you noticed the theme? It seems like a lot of our stories are about a Florida man. But this one is a story in Alabama about a Florida man. This Alabama man was arrested with a parrot on his shoulder while allegedly super high on mushrooms. So our gentleman, our dumb criminal, was arrested after reportedly fighting with Florida deputies. And the deputies were originally alerted to a man who was pounding the front door of a local home in addition to, doing something to a vehicle. The homeowner asked the man in question to leave, but he wouldn't cooperate. Needless to say, deputies were called. As they're on their way to the scene, they spotted a car that matched the description of the one at the scene with the guy that was there. The driver was later identified as Mr. Timothy Brandon Bowers. Now, Mr. Bowers was found sitting in the vehicle with a blank look on his face and a parrot on his shoulder. When the deputies approached the car, they noticed several weapons near Mr. Bowers and asked him to please exit the vehicle without the weapons for officer safety reasons. That's when the police say that the Mr. Bowers became combative and non-compliant. So, of course, they did the next best thing. Instead of knocking him over the head with a billy club, they tased him. It's a kinder, gentler world. Anyway, the police say that Mr. Bowers told them that he was doing nothing wrong, and he was just a little high on mushrooms. The police did find several items during the search of the vehicle, inventory search, just to make sure, everything's documented so it didn't go disappearing while it was in police custody. The parrot was taken away by animal control, and Mr. Bowers got a trip to the jail where he was charged with 2 counts of possession of a controlled substance, 2 counts of battery on law enforcement, that's an assault, resisting an officer, and possession of drug paraphernalia, and trespassing, going back to the incident at the home. My guess is he was probably pounding on the door because he thought he was somebody else because he was super high on mushrooms. And it all went from there. Hey, ladies and gentlemen, I am no teetotaler. I've said this before, and I will say it again. You want to do all that stuff? That's great. Just do it at your own home. But when you start affecting other people, that's when it becomes a problem under the law. And there's collateral consequences to all of that garbage that everybody wants to do. Go look at any major city today. You want to do fentanyl? Knock yourself out. Just don't do it out on the streets. Just don't be out camping on the streets. Don't be defecating on the streets. Do it in your own home. Oh, you can't because you lost everything because of the drugs? Ooh, yeah, maybe you shouldn't do them. Anyway, that's all we have for you today. Thanks for watching. Hope you have a wonderful weekend, and we'll see you next time on Crime Talk. And remember, the Constitution matters.